Hi, my name is Ann Lorero, and this is my case presentation for Week 4 of EDU 503 Sports Law. The case that I'm going to present is Jager versus Douglas County School District. The plaintiffs are the Jagers, that includes their son Doug and both parents. The defendant is the Douglas County School District in Georgia. In September of 1986, the Jagers filed a complaint against the Douglas County School District in the Northern District Court of Georgia. Their complaint states that their pregame invocation at their football games was typically given by ministers, and that it violates their First Amendment rights, specifically the Establishment Clause. The First Amendment: Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or of the right of the people peaceably to assemble, or to petition the government for a redress of grievances. The high school's band director was responsible for putting the invocation together as part of the pregame festivities before the home football games. This invocation often started with "Please bow your heads" or "Let us pray," and was typically given by one of the ministers of the community that involved some form of prayer. Well, this form of prayer came in conflict with the Jagers' personal beliefs, and that is why they filed suit. In the fall of 1985, Doug Jager brought his objections to the high school principal regarding the invocation during pregame. His high school principal then told the band director, and the band director came back to Doug and basically began to speak to him regarding Christianity. In June of 1986, a group from the school met with the Jagers and their council, and that group included Catherine Sheehane, who was the school superintendent, two ministers from the area that were part of the Douglas County Ministerial Association, and the school's attorney. Basically, they brought two proposals to the Jagers in hopes of finding a compromise for their objections to the pregame invocation. The first of the two proposed plans that the group brought to the Jagers was an inspirational secular speech. So it would take the place of an invocation, but there would be no religious content involved. The second of the two was called the equal access speech. And what that would do is still allow for an invocation with limited religious content. After the meeting concluded, the Jagers completely rejected the equal access plan and said that the only feasible alternative would be the wholly secular plan. And that's what they presented to the school's attorneys. At that point, two of the reverends that were involved in the meeting, Reverend Jenkins and Reverend Mountain, asked if they could give a revised proposal. And at that time, the Jagers decided that they would think about it, they would review the plan, but in the meantime, there could be no invocations at the pregames. In September of 1986, the school district superintendent, along with the principals of the high schools, decided that they would continue with the invocation and use the equal access plan. And a few days later, the principals went back to their high schools and informed those involved that they would continue with the invocation using the equal access plan, starting as early as a couple of days later for their first football game. Equal access plan. This plan states that school clubs and organizations can designate club members to give invocations, and any student, parent, or school staff member can seek to deliver an invocation. School government will randomly select the invocation speaker, and no ministers will be involved in selecting invocation speakers or in delivering invocations. And the schools will not monitor the content of the invocations. This case went to court in November of 1986, and in February of 1987, the court declared pregame invocations unconstitutional. It also denied the Jagers' request for a permanent injunction. It rejected the Jagers' claim based on the free exercise of religion clause in the First Amendment. And last, it rejected the Jagers' claim that the school district violated Georgia Constitution. There are a few different implications for this case in regards to an athletic administrator. First, I would say that if you are in an athletic administrator position in a state public school, please remember what your state laws are regarding the separation of state and religion. The second thing I would do is make sure that you are checking with your principal and your school district superintendent to make sure that you're not stepping on any kind of protocol that they already have in place, so that you are not getting into a position where you might have lawsuits brought against you. Lastly, I would say to make sure that you are looking at the traditions and protocols of your school as far as what has been done in the past. That typically is a good diagram for what you should follow in the future. Thank you for watching today, and I hope you learned a little bit about constitutional law.